Hello students and welcome to the lecture. So students, as we know that we have started the judicial activism, okay, in the previous lecture, and these are the topics that we have scheduled for the discussion under this particular series, like starting with the introduction of the judicial activism, thereafter the meaning of judicial activism, thereafter the judicial review and the judicial activism, thereafter the justification of judicial activism, thereafter the activators of the judicial activism, thereafter the apprehensions of judicial activism, and thereafter the judicial activism versus judicial restraint. Okay, so these are the topics that we have scheduled for the discussion. Okay, I hope that you have revised the previous lecture in the well enough manner before you have come for this lecture. Many times I have reminded you that is for your own benefit. So if you are doing these things on the regular basis, that will be beneficial for you. If you are not doing this, then that will be harmful for you. Okay, so basically if we talk about the previous lecture, I want you all to revise the facts and figures that we have covered in the previous lecture before we go forward. Okay, because in forward we will only be able to connect the things together, then we will have a knowledge of the previous thing. So basically if we talk about the judiciary in India, okay, if we talk about the judiciary of India, so as we know that basically we had brought it from the Constitution of United States of America, right? We had brought it, but we know that in USA the judiciary is separated, which means they have federal courts, they have provincial courts. The federal courts basically implement the national laws and the provincial courts basically implement the state laws. Okay, but we know in India we did a modification and basically we had established a integrated judiciary. Integrated judiciary. Okay, that's the thing. But what happened that besides the judiciary, the one thing also we had brought to India, that was the judicial review. Okay, judicial review is the basic structure and you can say that it is a power which we had given to our courts, okay, so that they could interpret the rules and the regulations as per the constitutional validity. Okay, many times I have seen that people often confuse the judicial review with Article 32. Many times I have seen it. Here is a difference between the judicial review and the Article 32. And what is this different? Basically, if we talk about the Article 32, so Article 32 declares Supreme Court as guardian of fundamental rights. Okay, and this similar article is Article 226, okay, which declares the High Court as a guardian of fundamental rights. That's the thing, Article 32 and Article 2026. Here you can say that basically their review power is confined to the fundamental rights. Okay, but when we talk about the judicial review, then the court having the power to look after the legislation and the executive and judge their action as per the constitution so that their constitutional validity could be defined. That's the thing. All right. But after judicial review, what we had seen that basically this was the year of 1947 when there was a person whose name was Sir Arthur Schlinger. Sir Arthur Schlinger, who was residing in USA, he coined the term, and the term is known as the judicial activism. Okay, which is the extended form of pre-existed judicial review. Okay, why? Because in judicial review they could check the constitutional validity, but in the extension and in the judicial activism, court even interfere in lawmaking procedure and even force the other two organs to discharge their duties. Court even interfere in the lawmaking procedure and even force the other two organs to discharge their duties in the judicial activism. So that's why it is known as the extended form of the pre-existed judicial review, where the previous one is only confined to the constitutional validity. The judicial activism goes far beyond the thing, and even this provides the power of interference and the forcing of two other organs to discharge their duties. Okay, that's the concept. Now I'm going to ask you the simple question: who were the four judges to brought judicial activism in India? Who were the four judges to brought judicial activism in India? That's the question I had told you in the previous lecture also. Okay, for this you have 40 seconds to think and answer, then I will give you the answer. Okay, just try to recall the names and last name only. I'm not telling you to recall the full name, only the last name you are required to recall it. Okay, so your time starts now. 1 2 3 4 5 6 7 8 9 10 11 12 13th 14th 15th 16th 17th 18th 19th 20 21 22 23 24 25 26 27 28 29 30 31 32 33 34 35 36 37 38 39 40. The time's up. So the correct answer is Justice Bhagwati, Justice Iyer, Justice Reddy, Justice Desai. Okay, these are the four pioneers of the judicial activism in India. Got it? That's a thing. So I hope that we have made a full, you can say, uh, the base before starting for today's lecture. So let's start. So basically, in the previous lecture that we had started the justification of judicial activism. Okay, like we know in government when we talk about the three organs. So the three organs is, the first is legislation, second is executive, the third is judiciary. Okay, so if we talk about legislation, role is in making of rules and regulations. Executive is role in implementing the laws. Judiciary is role is in safeguarding interest of people and checking constitutional validity. That's the thing. All right. So here we had seen that when we talk about the judicial activism, so the judiciary is somehow interfering in the work of two. Got it? They are interfering in the legislation, they are interfering in the executive. Okay, because they are forcing it. So basically that's why we had started the discussion over like what is the justification behind doing this, like how this step, this action could be justified. So we had seen the two you can say the opinions, and the third opinion that we are going to start here is from the Dr. Vandana. Okay, so the concept of judicial activism can be seen to be reflecting from the following trends. The first trend stands out for the expansion of rights of hearing in the administrative process. Like we know, generally when we talk about the judiciary and when we talk about the administrative, okay, so we know that the judiciary could only look after the rights when it's a matter of general masses, but when it's a matter of administrative action, then generally the scope of judiciary is limited as per the constitution. But under the judicial activism, the judiciary could even hear the cases of administrative process. It means that what happened to the person during the administrative inquiry or action, that could be heard in the court. The first thing is this. Second, the excessive delegation without limitation. It means that this act will expand the power of the judiciary, which is the guardian of people's right. So if the expansion of powers of judiciary will expand, the people's right will be protected. Okay. Third is the expansion of judicial control over the discretionary powers. What does it mean? Like if we talk about discretionary power, the biggest example of this is the directive principles of state policy. Popularly, we call it as an DPSP. We know that the directive principle of state policy is basically raised on the foundation of instruments of instructions. Right? Now, here I have framed a question for you. You all are required to tell me from where we had a finding of instrument instructions. Like which act provides the instrument of instructions. For this, you have 30 seconds to think and answer. Then I will give you the answer. And your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th, 14th, 15th, 16th, 17th, 18th, 19th, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30. The time's up. So basically, the instrument of instructions comes from the Government of India Act 1935. Okay, so basically the instrument instructions are provided for the welfare of the people. Okay, and we had modified it during the directive principle of state policy, which we had brought it from the Ireland Constitution, and we know that it is divided into social principles, the Gandhian principles, and the liberal principles. Okay, that's the things. And the articles included into the DPSP are the articles which are for economic and the social freedom and the democracy, because the political democracy has been provided by the fundamental rights. That's the thing that we have learned. Okay, but there is an fact and figure which we know that it is totally depend upon the discretionary power or the discretionary of the state. It means that no one is able and no one is allowed by the constitution to go to the court and challenge and say that the government is not doing, not implementing, not making laws and all about this. That could not be happen, right? So that is the main thing. Like expansion of judicial control over the discretionary power has been ensured by the judicial activism, that the judiciary could force the legislation and the executive to take the action and make the rules and regulations on it. Got it? Thereafter, expansion of judicial review over the administration, that I had told you right now. Promotion of open government. What do you mean by the open government? Like what the other two organs of government are doing, legislation and executive, this could be challenged and this could be bring to the light in front of public. Okay. Indiscriminate exercise of contempt power. Okay. Exercises of jurisdiction when none exist. Okay. Like if the government has not make any law which is for the welfare of the people, so the jurisdiction could be excised even the law does not exist, but the jurisdiction could be excised and the judiciary could force a legislation, thereafter the executive to implement the rules and regulations. Thereafter, overextended the standard rules of interpretation in its search to achieve economic, social and educational objectives. Passing of orders which are per as unworkable. It means that which are not workable right now. After this, now we have the next topic, stands for the activators of the judicial activism. Okay, let's talk about it. So there is a name, Upendra Bakshi. Okay, if I'm pronouncing it wrong and then I'm taking your pardon. Okay, he is eminent jurist, has delineated the following typology of social, human right activist who activated judicial activism. Like the people who exercises the judicial activism on behalf of judiciary and bring the matters to the court so that the matters could be discussed. So the first name in this is the civil right activists. This group primarily focus on the civil and the political rights issue. Okay, these are the first kind of activators. People rights activists. This group focus on the social and the economical rights within the context of the state repression of people's movement. Okay, it means that against the arbitrary power of states. Third is consumer rights group. These formation raise issues of consumer rights within the framework of accountability of the polity and the economy. Okay. Thereafter, bonded labor groups. The groups ask for judicial activism is nothing short of annihilation of wage slavery in India. Basically, this is also known as agreemental slavery. And if we talk about the, you can say the most common name, then you must have here about the Bandhua Mazdoor or Bandhua labor. We will talk about it in detail when we will have a discussion over the, you can say, human rights. Okay, sorry, not human rights. Human rights and fundamental rights both. Thereafter, citizens for environmental action. These group activist and activist judiciary to combat the increasing environmental degradation and population, as we know that it is a serious threat nowadays. Thereafter, citizen groups against large irrigation projects. These activist formations ask the Indian judiciary the impossible of for any judiciary in the world, namely case cease to and it is from ordering against mega irrigation projects because these are large projects for the economy. Rights of child group. These groups focus on child labor, the right to literacy, juveniles in custodial institutions, and rights of children born to sex workers. Thereafter, custodial right groups. These groups include social action by prisoners, right groups, women under state protective custody, and persons under preventive detention. Okay. Thereafter, poverty right groups. These groups legislate issues concerning drought and famine relief and urban impoverished. Indigenous peoples' right groups. These groups agitate for issues of forest dwellers, citizens of the 5th and 6th schedules of the Indian Constitution, and identity rights. Thereafter, women rights group. These groups agitate for issues of gender equality, gender-based violation, harassment, rape, and dowry murders. Bar-based groups. These associations agitate for issues concerning autonomy and accountability of the Indian judiciary. Okay. Media autonomy groups. These groups focus on the autonomy and accountability of the press and instruments of mass media owned by the state. Assorted lawyer-based groups. These category includes the critically influential layers groups which agitate for various causes. Thereafter, assorted individual petitioners. This category includes freelance activist individuals. Okay, so these all are the activators. Thereafter, apprehension of judicial activism. Let's talk about it. The same jurist about which we have taken the you can say view and consideration during the activators, Upendra Bakshi, also presented a typology of fears which are generated by the judicial.
Other fears generally we face when we talk about the judicial activity. He observes the facts entail the invocation of wide range of fears. The invocation is designed to break into a nervous rationality among India's most constitutional justice. And the fears are these types of fears. First is Ideological fear. Are they usurping powers of legislature, the executive, or other autonomous institutions in the civil society? This is the first kind of fear. Thereafter, epistemic fears. Do they have enough knowledge in economic matters of Manmohan Singh, in scientific matters of Kazars of atomic energy establishment, the captains of councils of scientific and industrial research, and so on? Why? Because no person on this earth having the ability to be the master of all. So if the judiciary is interfering in the works, maybe the judge who is interfering is not having the knowledge of that particular field at all. Okay, so that's the fear. Thereafter, another one is the management fears. Are they doing justice by adding this kind of litigation workload to a situation of staggering growth of arrears? It means that already we know that the nation having the limited resources. So if they are forcing the legislation and then the executive, then are they doing it right or not? Thereafter, legitimation fears. Are not they causing depletion of their symbolic and instrumental authority by passing orders in public interest litigation, which the executive may bypass or ignore? Would not the people's faith in judiciary, a democratic resource, be thus eroded? Okay. Thereafter, the democratic fear is a provision of public interest litigation nurturing democracy or depleting its potential for the future. Okay, like we know, if anything government does, mainly the people go and file the PIL. So that's what the thing. Biographic fears. What would be my place in the national affairs after separation if I overdue this kind of litigation? Because we know after your separation or after your retirement, you will become a normal person. So that's the thing. Okay, so these are the apprehensions or the fears which comes in the mind of the judges during exercising the judicial activism. Now, we have the judicial activism versus the judicial restraint. So let's talk about the judicial restraint. Already I had told you in the previous lecture, so I'm not going to do much emphasis on it. Okay. Judicial activism and judicial restraint are the two alternative judicial philosophies in the United States. Those who subscribe to the judicial restraint contend that the role of judges should be scrupulously limited. Their job is merely to say what the law is, leaving the business of lawmaking where it properly belongs. That is with the legislators and the executive. Okay, it means that the judges only having the responsibility to check the validity, not the interfering into the matters of the legislation and the executive. Under no circumstances, nor ever should judges allow their personal political views and political agendas to color their judicial opinions. This view holds that the original intent of the authors of Constitution and its amendment is knowable and must guide the rules. Okay. Thereafter, assumptions of the judicial restraint. In the USA, the doctrine of judicial restraint is based on the following 6 assumptions. First is, the court is basically undemocratic because it is non-elective and presumably non-responsive to the popular will because of its elite oligarchic composition. The court should defer wherever possible to the more democratic branches of the government. Okay. The questionable origins of the great power of judicial review, a power not specifically granted by the Constitution, but it is adopted over a period of time. The doctrine of separation of powers, as I have told you, there are 3 organs, legislation, executive, and judicial. All of them having their defined role. So if the one organ is interfering in the roles and the responsibilities of other organs, then this is basically disbalancing of the defined roles. Thereafter, the concept of federalism, dividing powers between the nation and the states requires of the court deference towards the action of state governments and officials. The non-ideological but pragmatic assumption that since the court is dependent on the Congress for its jurisdiction and resources and dependent on public acceptance for its effectiveness, it ought not to overstep its boundaries without consideration of the risk involved. Thereafter, the aristocratic notion that being a court of law and inheritor and custodian of the Anglo-American legal tradition, it ought not to go too far to the level of politics, Law being the process of reason and judgment, and politics being concerned only with the power and influence. Okay, so from the above, it is clear that all assumptions except the second dealing with the social review hold good in the Indian context too. Alright, so students, basically here we had finished the judicial activism versus the judicial restraint and the topic of judicial activism at all. Okay, in the next lecture, we will start with another important topic. Till then, just revise the facts and figures that we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture and